It's so nice to see you all here. So we are thrilled to be talking to you about child-focused mediation, and we're going to talk a little bit about child-focused mediation and also child-inclusive mediation and what led to this and voice of the child and all of those pieces. So I am going to kick us off and just give a little history about elevating children's voices in family law disputes. So, I'm just gonna, there we go. So if you can just advance the slide, um, that'd be great. Good. Okay, so way back a couple of hundred years ago, I think from those of you that remember your history lessons, children were really seen as property in the family. And as a result, they would, upon reflection in terms of how we view children today, were not always treated in a way that we would hope children would be treated. So they were property of the family, they were moved around a lot, they were working a lot in very difficult conditions. And then over time, the pendulum really swung to the other way, which is where we were very overprotective of children and not wanting them to say too much or get too involved in adult type things or even in the running of government or family life or anything in general, really trying to be very overprotective of them. And now we're trying to find a bit of a happy medium. And the United Nations Convention on the Rights of the Child helped us to sort out some of that happy medium in terms of children's rights and our responsibilities as adults. So what the UNCRC said is that the opinions of children and young people should always be considered when adults or other people are making decisions about things that involve them. So this is very relevant to family law type situations. So their opinion should not be dismissed because they're very young or depending on their strengths and needs. They should always be taken seriously and consistent with their evolving capacities taken into account. So not only should they be given an opportunity to share their voice in decisions that impact them, but Article 12 of the United Nations Conventions of the Rights of the Child also says that children and young people should be given information that they need in order to make good decisions and also to reflect on their views and preferences in different activities that they might be engaged in and when other people are involved in decision making about them. So you have the UNCRC that kind of lays the groundwork for what has unfolded in the years since until where we find ourselves today. So in Canada, under the Charter of Rights and Freedoms, children have the same rights as all other humans, regardless of their age or anything like that. And then the Divorce Act now also has really made much more explicit children's rights and how important it is to have their views and preferences heard. So when making decisions about parenting or parenting time, parenting decision making, all of those things, the court is expected to consider children's preferences wherever that's appropriate. So it's not just that they should, or it's not that they could, or it would be a good idea to. The Divorce Act really says that the court must consider the children's perspectives. They must, consider the children's views and preferences, and that those views and preferences really have to be given due weight, of course, depending on the child's age and maturity and things like that. And there are going to be some rare circumstances where it's going to be difficult to ascertain what the children's views and preferences are. But to the extent that they can be ascertained, the court must consider these. And so the same is with mediation as well. And, Vicky is going to talk a little bit more about the standards for OAFM in terms of elevating the child's voice in a mediation process. But just one last piece of, groups that have weighed in on this issue is the Supreme Court. And what they said is that, not only should children's views and preferences be heard, but also children have independent legal rights independent of their parents. So those are really the foundational pieces in terms of legislation and guidelines and international standards related to children's views and preferences. If you can advance the slide, then we can just talk a little bit about the research as well. So what we know just in general is that people do better, they have better well-being of all ages when they are able to participate and given some choices in decisions that are being made about them. So there are lots of studies in the school system, in residential placements for children, where if they can participate in some of the decision making and some of the planning and have their views and preferences heard by those making those decisions, that their behavior is better, their well-being is better, and their emotional outcomes are better. It's the same all the way through the lifespan. So many of you who have aging parents might have heard of the importance of including older adults in decision making and planning in the long-term care facilities in which they live, or in hospital-based settings. So hospitals are also really moving towards having patient input into planning meetings and decisions and discharge planning and all of those kinds of things. And the reason is because we know that the research tells us that when people participate, they tend to have better outcomes. So in terms of these types of pieces, we have, of course, had research on elevating the voice of the child in family law dispute situations. The OCL did a very large pilot study on voice of the child reports, and the outcomes there were very, very good. Not just in terms of the children feeling valued and appreciating their voices being heard and elevated, and having relevant information for their family situation, but it also had a huge impact on settlement. So parents viewed it as, and lawyers talked about that information really advancing settlement more quickly and in more cases than they would have expected otherwise. And judges have also found it to be extremely valuable. So that's some of the research pieces and some of the background. And now I think if we advance the slide, it's on to Vicky.
I suddenly have too many jobs here and I can't coordinate them all. Okay, so in terms, I do want to preface my comments by saying that the standards of practice when it comes to child inclusive mediation, these were created a number of years ago by a committee. And certainly in reviewing these standards, it's clear that it's time to update them. So you're going to notice that some of the language within the standards is interchangeable. And certainly I know that we're making efforts to try to be clearer in the language so as to reduce the level of confusion in terms of different procedures to hear children's voices in the scope of ADR. So the current standards basically state that in consideration of the vulnerability of children, mediation must be child-centered, and mediators must provide education, awareness, and understanding of the needs and best interests of the children experiencing the conflict of others. So in addition to being neutral, we also need to help educate those that we're working with in relation to hearing children's voices. And so part of that is educating the parents in terms of the importance of the voice of children in family contact, and consider whether and how they can have these voices heard, because there's a number of different ways that their voices can be heard in a supportive way. It's regardless of the method of inclusion for children, their participation must be voluntary, and no child should ever feel pressured into talking with a mediator or any professional for that matter, recognizing that not all children want to take us up on the opportunity to have their voices heard. So mediators have a wide range of options to bring in the voice of the children, directly or indirectly. And certainly if there's a lawyer involved through the Office of the Children's Lawyer, we really do want to reinforce that when the Office of the Children's Lawyer is involved, they are the voice for the child. And so we should always attempt to meet with the OCL in family mediation, but definitely in child protection mediation. It is a requirement that if an OCL has been appointed, that they are actually part of the mediation process in child protection mediation. So one of the procedures to be able to hear children's voices is a co-mediation model, where one mediator speaks to the child and the other mediator then speaks to the parents. Mediators can also interview the child's therapist with consent, of course. If there's a social worker or psychologist involved with the family, again, providing there's consent, the mediator can speak to those to try to ascertain what the child's voice is in relation to their wishes. There's utilizing a voice of the child report, which will get discussed a little bit later as well, which is very different than the child inclusive mediation, which our focus at OIFM is the child inclusive mediation, not the voice of the child reports. Offering the child an opportunity to participate in a conversation verbally, in person, or in writing, over the telephone, or by play or storytelling. It's important, I apologize, I'm getting over a cold, so I've got a squeaky voice, so I do apologize. Mediators should always utilize the least intrusive method of bringing the child's voice to the table, considering their age, their maturity, and other relevant circumstances. It's important that as mediators, if we are going to be meeting with children directly, that we have the competency and the experience in doing so. Children are very vulnerable, and we need to make sure that we're practicing within our lane in terms of competency. And if we are going to be doing child inclusive mediation, the standards of practice of OIFM dictate that mediation must be a closed mediation. And any parent, guardian, or child involved in the process, child over the age of 12 must sign consents. Certainly, I know when I do child inclusive mediation for younger children, I do get their consents as well, but over the age of 12, signed consent is required. It's important that we meet with children more than once, and we ensure as mediators that children understand that they're there to give their input and to be heard, but not to make the decision. So, voice, not choice, and to never directly ask them to choose between their parents or caregivers. Having said that, we have some very precocious kids that will say, well, don't you want to know where I want to live? Certainly, if they want to tell you that, by all means, but we don't put them in the position of asking them directly where they want to live. And we need to ensure that children understand that information related to safety cannot be kept confidential. So child protection concerns do not remain confidential. Additional standards, we have to ensure that each party to the mediation has an opportunity to bring the child for a meeting. So if there are two parents, parent A brings the child to one of the meetings, and then parent B brings the child to the next meeting. Minimally, there are, two meetings with each child. If there are siblings, then a sibling should be seen separately. And we clarify with the child what information the child was shared and which is to be kept confidential. And mediators should encourage parents to share the parenting plan with the children, emphasizing that their voice was heard and considered. My apologies. I think
thank you, Vicki and Kim. Jumping in now just to talk a little bit about the history. And most of you are aware of this, and I know there's lots of questions and comments in the chat that we'll open up for further discussion in a little bit. But in terms of the mediation framework and children's voices, we have to reflect on kind of where it all began. In terms of family mediation, was really focused, the mediator working with the parents who are trying to bring forward their, what their interests are, wishes, needs, and bringing to the planning process and participating in developing a plan. The mediator and parents originally were not particularly focused on children's needs, and in fact, they did not meet with children. However, over time, there was some clear benefit demonstrated in reminding and helping to educate parents about thinking about this from a child-focused lens. So this is where the terminology child-focused family mediation really comes from. It's where there's an intentional effort to facilitate the parents really thinking about focusing and bearing in mind what may be going on for the children. It may involve, the children's lawyer in terms of participating in the process, or there may be other ways that children's points of view may have come through a child protection or children's aid input, or through other means such as voice of the child reports that other professionals may conduct and share with parents. The key here is when you shift from family mediation to a child-focused family mediation, you're still not meeting with the children. So it's the parents and the mediator, and different techniques have been incorporated into the process. Some of you, I'm sure, can sort of put a few additional ones in the chat, but just to start it off, some mediators will get parents to bring along pictures, either on their iPhone or a printed picture to put on the table to really sort of keep everyone, the children are at the center of the planning, keep reminding folks in terms of, these are also to be considered as planning unfolds. Other ways that children's points of view may come forward, parents may share as they're participating in the mediation what they have heard from the children, what they think they've heard from the children, what their own views are in terms of what their children's thoughts and wishes are. And that sometimes that's accurate. Other times it may be a misread. Next slide, thanks. So in terms of the child-focused mediation, the mediator, as I said, assists the parents to develop a parenting plan while considering children's developmental needs. They may participate in providing some education around child development in terms of what's typical of certain ages, what are some of the things that as professionals we've heard from children in terms of different thoughts, needs, and dynamics around separation and divorce, what their questions often are. But mediation of the parenting plan is based on really the parents' knowledge of the children. So again, it's missing the direct input of children. The mediator advocates for the children in a general sense by having the parents to focus on the children. As we said, maybe it's putting the picture in the center of the table, and really trying to encourage and evoke a dialogue between the parents about the children. The mediator in this child-focused mediation, just to highlight again, the mediator does not actually meet with the children, and that piece is not included in a child-focused mediation. And next slide. So some of the disadvantages, and it's been pointed out in the chat by many of you, and I'm sure you've encountered some of these dynamics. Some of the disadvantages of child-focused mediation, which does not directly include children in the process, is that children don't always share their thoughts and feelings with their parents. They may take time. They may worry about hurting feelings of one or both parents. There's often some incredible assumptions by one or both parents about kind of what the children's views and preferences are. The parents may clearly be at odds over the children's needs, views, preferences, see it very differently. Many parents, when they're so focused on all the other things they need to sort out, finances, some of the legal aspects, housing, the extracurriculars, planning, and breaking down kind of sharing of household items, etc., they're not always attuned to the children's needs and concerns. And the other thing that's been pointed out by many of you in the chat is that children may say things to parents really to appease them. You know, they may say exactly, they know what the parent wants to hear, and they may say that, and it may not be an actual indication of what they wish to have happen. So there are some disadvantages. So more recently, we've been doing some educating and supporting and trying to encourage more folks to take a child-inclusive mediation framework. This does include the children in consultation with the child in a supportive and developmentally appropriate manner through interviews, younger children perhaps through different activities, drawing activities, etc., getting them perhaps to write something. And it really sort of also makes sure that the children are very clear that they're not in a decision-making role here. We're interested in their voice. We're not interested in them making a choice. It's, again, an opportunity to understand the children's experiences, views from a developmental framework. A big piece of child-inclusive mediation training is really focused on understanding child development, understanding the changes that can arise with neurodiverse children and others who have experienced trauma and other difficulties. The child-inclusive mediation is about validating the child's experience while providing some basic information that may assist their present and future coping. So sometimes it's really, bringing forward what we've heard from the children in terms of some of the things that they find helpful in terms of coping, different strategies, their support network, etc., that may have been forgotten in all the other changes that the parents are trying to address. And a big piece of child inclusive mediation is sharing information about resources, sharing some of those coping strategies that have been learned from the children. The provision of feedback to the parents in a manner that helps them to better understand the child's experiences and needs. So the key is feedback that does not place the child in any harm. It's designed to bring forward what the child has given permission to share, and it's only focused on facilitating the parents to keep in mind what the views and preferences and worries and concerns of the children are. So again, child-inclusive mediation is really about encouraging parents to reflect on the needs and preferences of each child. So you think of a sibling group, you may hear very different things from the children when you participate with them in the interview process. And that information then from each of the siblings that you've received permission to share is then brought forward to facilitate to participate in helping parents and the mediator then to continue to develop a parenting plan for this particular family. The child-inclusive mediation, as Vicki highlighted, we talked about it as it's important to recognize it's a closed process. Process is complete within a context of closed mediation and is confidential, except in situations where you've got a duty to report, of course. The child's voice, you share only what they give you permission to share. And it's not added directly into a mediation report. It's information for the parents to reflect on, for the mediator to help the parents sort of keep some of those elements in mind as they develop the parenting plan and to inform the plan. It's only done when there is consent. And again, the children have the final say over what is to be shared in terms of those things. And you, as a trained child-inclusive mediator who's done the interviewing with the children, are also to bear in mind your own clinical judgment, because there may be some times where you opt not to share, even though the child has given permission for it. There may be some concerns about worry about harm to the child, safety issues, etc. And so you may put some limitations on what it is that's shared, or you may shut down the process. And we'll talk about some of that as we get into some questions and general comments.
Okay, I can talk a little bit about the research. So there have been some research studies done over the years, and there's some references there at the bottom. Some of it has been directed by Jennifer McIntosh, who's done a lot of work in this area. She's from Australia, so her research group, and she collaborates a lot with people from different countries as well to sort out the outcomes associated with Voice of the Child reports, child inclusive mediation, child focused mediation, and different types of family dispute resolution processes. So in the research over the years, what they found is that parents actually, and this is the same as the OCL study, when the children's views and preferences are included, they show greater satisfaction with living arrangements after. So the plans are often more durable when the children's voices are included in mediation and in court-related processes. Most of the parents, the majority of the parents in this study said that their children's feedback had the greatest impact on their ability to resolve the dispute. And certainly in terms of aspects of the dispute that are related to parenting time and things that impact the children also in terms of extracurriculars and vacation and those types of things. Interestingly, they did a study where they compared child inclusive mediations. This is when the mediator meets directly with the children versus child focused mediation, where there's an intentional effort to highlight child development and children's needs and to get input from the parents about the children versus family mediation as usual. And what they found was that afterwards, in the year following those different types of approaches, child inclusive mediation had less motions, hearings, and orders compared to child focused mediation, as well as compared to family mediation in as usual. So child focused mediation was resulted more durable plans than family mediation as usual, but child inclusive mediation had the least motions, hearings, and orders, which is really what the outcome we want for families. We want them to have success in the mediation process and have plans that can carry them forward. All right, so the next piece, and we've been monitoring the chat a little bit. I think children are very vulnerable. We want to make sure they're safe. We want to make sure that, they are well taken care of. And so there's a lot of fear in terms of doing this type of work. And so, we really we're going to ask you to lean into that a little bit as we've been talking through some of these things. There are family situations where people would have concerns, high conflict, family violence, where there's some child abuse. And so, we'd be worried about safety concerns. But if you reflect on the history that we talked about earlier, just because parents are not behaving well does not mean that children should lose their rights. So all children have rights regardless of their parent behavior. So that's the first thing to consider. The other piece is that children, Vicky talked about this in reviewing the standards. Some kids want to participate and some kids don't. So, we've definitely had kids who we have interviews with them. They share a ton of information with the mediator doing the work. And then when the mediator asks them what they want to share back with their parents, they say nothing, like, thank you for hearing our voice. We really appreciate being able to talk to someone about this, but we don't really want anything else going forward to our parents. And that is their choice. So it's not that they have to have their voice heard, it's that they have the opportunity to share their voice, their views and preferences with someone and to have someone carry that forward. The other piece to think about is that, when there are major clinical issues, these are some of the families that you might be screening out of mediation. There are other approaches to elevate the child's voice in family dispute resolution, right? You might have a family where there are so many concerning issues that they need like a full evaluation, like a Section 112 evaluation or a Section 30 evaluation in order to sort out really extensive dynamics that are not easily managed in mediation, and sometimes not even really easily managed in court, right? So that's why some of these assessments get ordered. And then that's a different process for elevating the child's voice. Those types of assessments do include the child's voice, but they just do it in a different way. So the idea is that children have these participation rights. We want to honor those rights, but it is up to us as adults as well to figure out the best implementation approach for those rights. So certainly all the work should be child-focused, and whatever we can do intentionally to create child-focused mediation and child-focused work in general is critical. Some families will do very well with child-inclusive mediation. It'll be really important for the kids to have that opportunity. Some families need a different approach that will sort out some of those other pieces. It's important to keep in mind that the kids, while they share their voice, they're one piece of the puzzle, right? So when you're doing mediation, the parents are contending with many, many different things, and they have to weigh, and the mediator is helping them weigh all the different pieces of the puzzle that need to come together to have them make a parenting plan that's going to work for their family. And so the child's voice is one piece of that puzzle, but it is in context of all the other things going on in the family. And so mediation is a really, a wonderful approach to facilitating the balancing or helping the parents balance all of those pieces so that their children have their participation rights heard, but also they can make decisions. The parents can make decisions that meet the needs of, the views of each child. They might have multiple children and also other things going on in their life, like work schedules and all different kinds of things that could be that factor into decision making for parents. So in terms of, and we're going to open it up for questions, but just in terms of next steps, in your own work, for those of you that are working with children, we really hope one thing that you take away from this webinar is that there's some reflection on how we can, include the child's voice differently or more, or for those of you that are not doing that yet, like how you might be able to elevate the child's voice in the work that you're doing with them, given what you know now about the history, the trajectory, the research, and also the children's rights viewpoint. How can you, what kind of implementation approaches as you as an adult can use in order to facilitate that voice being heard in a way that does no harm and that ensures safety, but balances out their needs as well. And then the last piece is, Vicky had mentioned having competence in meeting with children and understanding how all the pieces fit together and having really good, strong, robust processes for, implementing the rights, but also knowing when to having an off ramp. So, knowing when it's maybe not the best approach or another approach is needed. So all of those pieces do benefit from some training. We just ran a training recently, and there's a new one coming up in April as well that might help sort out certainly how to like the process issues to make sure there's some clear guardrails and information about decision points for how to do the work. And then also Dan had talked about some education pieces around interviewing in this context, which is different than interviewing, teachers interviewing children or those kinds of things. And then, the child development piece as well. So there's a lot of activity in the chat. So maybe we'll just.
So maybe we can take the slides down and just sort of put everyone on the screen and open it up a little bit. And thank you for all that have sort of commented and assisted in responding in the chat to the different elements that have arisen for each of us. And thank you for all who attended today in terms of those pieces. So what you're hearing is just a snippet of what we typically do in a 3-day training focused on how to ensure, and I see many familiar faces in terms of folks who've already done some of the trainings related to bringing children's voices into the different processes. And thank you all for coming and participating today. So comments, questions, you either put it in the chat or you can raise your hand. Marianne?
Thank you very much for pulling this together. Just a couple points I want to make. It's really good to hear about the research of child-focused mediation. I had a hunch about that, and I'm glad to hear that the research is agreeing with my hunch. One of the things that I'm kind of putting out there for others to comment on, and is that and there's degrees of this, but particularly when it's at a high level of concern, I try to look carefully for those cases that are really a child welfare matter disguised as a custody and access dispute. Because if the conflict is, and they're not usually neat and tidy, but some of them are kind of more clear. If the conflict is primarily based on one parent trying to really protect the child who's truly at risk from the other parent, then that to me is not a negotiable situation. And I have found myself as a mediator finding more and more of these cases, because there is more of a tendency, and I am generalizing, for CAS to kind of go, no, go back to mediation, where I'm thinking, wow, that just escalates the risk to the child. And I think those are very different cases from ones where, there's allegations of, well, she's not feeding him properly, or I don't like this, TV show they're watching or whatever, which are also concerning. But some of them are really child welfare matters, and they're pushed into mediation. And I don't know, I just want to hear people's response to that, because you're putting the parents in a situation where they're negotiating about safety, and it's the parent who's concerned, anyway, you hear, I think I made my point. I just want to hear from you about.
Well, I think that, you raise a really good point in terms of, examining kind of what's at the core of what some of the struggles and comments and accusations might be, in terms of, a combination of perhaps a child protection and family, family law matter in regards to separation and divorce. There's a clear reason why the training for a child protection mediator is 6 days in length and is intensive, and there are clear criteria in terms of passing and the supporting the growth of individuals, so that they can balance all of those safety issues, power struggles, the different aspects that arise, and that they're able to touch base with the individual who's making the referral and talk about whether this is an appropriate matter for this course of action, or whether it's one that would be better suited to perhaps a parenting capacity assessment, or some other type of way of bringing all the information to the surface to help the decision making that needs to arise.
Well, just to be clear, I was talking about ones that have been pushed out of the child welfare system and shoved into the family court system, saying it's not a child welfare matter.
Where, oh, yes.
Yeah, right. Okay. Yeah. Okay.
Yeah. And, again, that's the reason for the, the standards that focus on competency and, focus on the skill of the mediator, being able to get at and determine, what are some of the things that we really need to pay attention to. It's why so much, the annual requirement for ongoing training around intimate partner violence, safety issues, etc., is a core element for those that are doing mediation work, as well as other social service professionals, that truly benefit from that ongoing training too. in terms of, teasing it apart and understanding all of the risk elements, doing the proper screenings, determining whether this is one that is viable. To say that it can be done through a shuttle mediation process, and that's going to address all the safety issues, that doesn't work if someone is not feeling safe enough to even make a comment from the separate virtual meeting room that you've set up, etc.
There's some good information about voices of children in family law disputes where there's domestic violence on the Family Violence Family Law website. I'll put it in the chat, but it's part of the domestic violence community of practice that Dan and I sit on. And there's a webinar that includes some judges as well as a child with, well, now an adult upon reflection with some lived experience. And her perspective is that while there are risks associated with hearing the child's voice, there are certainly very significant risks with not hearing the child's voice as well in domestic violence situations. So I'll put it in the chat. There's a brief, like a written document that's really, really useful about this. And then there's also the webinar associated with it as well. And there's, many great resources there on a lot of topics that we all struggle with in this area.
And Luke's Place website also is another area to really sort of tap into additional information related to these challenging struggles that many of us encounter in the referrals that perhaps cross your desk. Other comments, questions? I've lost my chat function here for some reason. So if someone's putting it in the chat,
Hannah has a question. I'll just read it out if that's okay.
Thank you. Yep.
Okay. I'm wondering if anyone has encountered, someone just did a new message. I'm wondering if anyone has encountered a parent or parents who are resistant to elevating the voice of the child, i.e. they're just a child. We are the adults. We make the decisions. If so, how have you dealt with that?
So great question, comment. You said Hannah. That does come up, and it certainly comes up when parents are all about controlling what unfolds rather than really listening to and getting themselves educated about all of the aspects that need to be thought about. So, the Divorce Act speaks very clearly about the role of the child's voice in the process to be considered. Ideally, whoever is supporting these individuals, whether it's in the mediation process or other process, part of their task is about, the education component. It's also, a piece that sort of needs to be reminded of the parent is that the children are not making the choice. So it's their information that the parents then reflect on, and they may be able to make use of it. It may not be something that helps in some of the ultimate decisions around I'll use the example that was in the chat in terms of relocation. There's a lot of things that would need to be thought about and reflected on in a challenging topic such as that, but at least children should feel that people are interested in knowing what they're worried about, what they're thinking about, and that they have an opportunity to get some feedback, perhaps from the mediator, ideally from the parents, in terms of what it was that they used to come up with the plan and why certain things that they were really hoping for wasn't possible. It may be that financially it's not possible to continue in the 15 extracurricular activities that some families are engaged in just because of the changes in the financial situation.
Yeah, I think that's right, Dan. Like the information that you get in children in interview is not just about parenting time. There's just so much other valuable information that parents would and should want to know, like how their children are feeling, maybe about their friendships at school, because there's been so much going on in the family. Maybe the parents have been less attuned to what's going on at school, their interest in extracurricular activities, and even just, sometimes kids have questions, as Dan mentioned, and you can bring those questions, in the interview, the children had the following questions, and then part of it can be the parents figuring out how they're going to address those questions for the kids, which is really, really important for the parent-child relationship. So it's not just about, you know, how much time the child is going to spend at each home, but, you know, all the aspects of the child and getting the information that they need to have good well-being in the short and long range.
I'm not sure if Dan's about to speak. It looks like you are, Dan.
Might be unmuting himself.
Oh.
If you do have questions, I think you could use the raise hand feature. Some people are direct messaging me with questions, so I'm not sure if I'm given permission to share your direct message questions. So if you have a question, maybe put your hand up and then you can ask it verbally. We're a small, friendly group.
And there's some great answers in the chat as well. Thank you, AJ, for your response to, I think, Hannah's question or someone else's previous question in terms of reminding folks about the various things that need to now be thought about and addressed.
And people might not, you know, parents might, you can do the interviews at any point, right? It doesn't have to be at the beginning, doesn't have to be at the middle. So as parents develop comfort and trust in the mediator, they might be more open to including the child inclusive piece as time goes on. You know, at the beginning of a mediation, they're anxious, they haven't met the person before. Like there's a lot of rapport building and trust that develops that, you know, then if they're not interested at the beginning, you know, continuing to remind them about the importance of it and how it's embedded in the legislation down the road through the mediation, they might feel more open to it.
There's also comments in the chat about recognizing the for some parents, they're really worried about the children getting caught in the middle of some of the conflict, being pulled into it. And so part of your role as the mediator is to educate them about, you know, how to support children through some of those things, how to keep them out of the conflict in terms of those dynamics. You've got your hand up, Farzana.
Yes, thank you for letting me asking the question. I have a question regarding the mental health situation of the children. I think it's very important because I think my question is, does mediator want any background of mental health of the children? Because some of the children are in situation that it needs different implementation and approach to reach to them for asking question and interviewing them, because some of them have some mental health issue that it makes us, yes. I want to know, this history is shared with mediator, and does mediator ask for this information or not? Thank you.
Great questions. I think one of the things that all of us should go back and do is revisit our intake process and questionnaires. What are the things that you're gathering in terms of background information as you do the initial taking the referral, doing the screening process? What are you hearing in terms of a little bit about each of the children? You know, if you're going to do child inclusive mediation, getting that information will help you develop some rapport, think about some of the things that are perhaps going to be great ways of connecting with children and helping them feel at ease in the interview process. But if you're not asking about what else would be important to know about the children in terms of perhaps language difficulties, learning disabilities, mental health struggles of the parents or children, that may be factors to play into your decisions, then expand your intake questionnaire. You know, really get sufficient information that you feel that you have what you need to move to the next stage, and that you can make some good decisions around, you know, this is the proper process. This is some of the key things that need to bear in mind. Here's how I need to adapt my process, perhaps, given some of those dynamics. And, you know, the mental health or health aspects of each of the parents and all the children would certainly be one element that I would be very curious about. Yes.
And the
And-
mediator can do the interview with the children with special needs, or it needs other specialists co-mediate this mediator.
Yes. So for some of us, for example, I would turn to Dr. Kim Harris to do the interviewing with children that have autism, for example, an area of specialty of hers, or neurodiverse children, an area of specialty of hers that I wouldn't want to step outside of my own competency areas and focus on some of those pieces. And I'm sure many of you have a network of kind of who you might think about and do perhaps the co-mediation with, to bring in someone else who is from the appropriate culture, the appropriate background and dynamics, perhaps the appropriate gender in terms of some of the pieces that may be a factor in some family circumstances, to help facilitate the process. And in other cases, you may wear both hats, have the skill and feel that you've got the skill to do all those elements.
Thank
And
you.
just to piggyback on what Dan was saying, I'm not sure whether it was made clear during the presentation, but the same protocols for conducting family and child protection mediation are in play in child inclusive mediation. So comprehensive intakes are completed with both parents prior to any interviewing with the children. So you would be canvassing all of those issues in terms of mental health, domestic violence, power and control, special needs for the children, like all of those different areas are still being discussed with each parent privately during a private intake. So just to make sure that that part was clear.
Thank you.
Thank you.
I can give a really quick example just to maybe hit this home. I was working with two parents who had been having shared parenting for a number of years. And the child who was 11 at the time, there were 3 children, but this was specific to the 11-year-old, who each parent was saying had been saying that they wanted to live with the other parent primarily. And so it was set for trial, and I did the child inclusive mediation. And in meeting with the child, he was so perfectly clear in saying, I just want their conflict to stop. And I have told both parents, I want to live with the other because it's what they want to hear. And, obviously that was a difficult discussion to have with both parents, because the child consented to me sharing that with both parents. But they were able to hear it, and they were able to recognize that really it was the parental conflict that the child was trying to avoid, and not wanting to necessarily change the actual parenting schedule. So it can be quite empowering, bringing those voices back to the parents to hear through a neutral person. Are there any other questions or comments?
Vicki, what about those of us who are thinking about doing child-focused mediation, and the parents are relatively low conflict, and the couple comes into the room and they are very demonstrative and descriptive of their child, and we talk and think about the wishes and views of the child throughout the mediation. What would be your advice in terms of any next steps for making this a more child-inclusive mediation, if you would suggest any?
I don't know whether it necessarily needs to be child inclusive mediation. You're certainly being child focused there, right? So I would think that I wouldn't want people to leave here thinking that all mediations need to be child inclusive. It's hearing the child's voice that's important, right? And so how does that voice come back to the table? And if both parents are very clear and being child-centered and child-focused, I think we've met that obligation.
Okay.
Yeah.
I really wanted that point to come across because I think that we did a member survey, and that's a little bit of how this webinar came to be. Is we asked, do people do our mediators practice child focused mediation? And many of you said no. And I think what we would like to change that narrative is yes. And there are some ways that you're bringing the child's voice in through the good word of parents, and that there's no conflict between what the parents are saying. And, it's a very, very natural conversation. And, oh, this child would like this, or this pillow has to go here with this child, or whatever it is. I think that I'd like the members to feel confident that this child focused mediation could be the only step that you take in a child focused mediation. And then you can say, yes, in this situation, I was child focused without any further interventions. Dr. Vanita Puri has her hand up.
Hi, just a question out of curiosity. I'm just wondering if anyone's had experience working with sort of intergenerational or extended family members. Like, I work a lot with the South Asian community. I'm South Asian myself. And so sometimes the grandparents are quite involved in the parenting, as well as the immediate parents. And there are different family dynamics there in terms of power and hierarchy and those kinds of roles, in terms of decision making. So I'm just wondering if anyone's had experience with sort of combining, or what is your process for, if, let's say, the in-laws and the other side of the family, the parents, grandparents want to be involved. Like, how do you navigate that? I've had some challenges with different, like, sort of family members, and so just curious what people's experience is. That's all.
Well, I'll start it off, but certainly others can join in. I think that it's better to have people present and at the table if they are playing a role than a behind the scenes disruptor, I would say, or disturber in terms of those pieces. And so if you've got the consent of all of those involved to open it up and bring everyone into it, the more that can contribute to ensuring that a plan is workable. And I know that that's a model that certainly comes out quite often in child protection mediation, where you've got to rely on lots of different folks, perhaps in terms of facilitating transportation to counseling and services and medical appointments and things of that nature. We can't be committing people to do something unless they consent to it and they're willing to take on some of those roles. So open it up if everyone's willing to, but also then look at skill, competency. I would bring in someone additional to work with me on an intergenerational one to help facilitate that, just so that you've got enough eyes and ears tracking all of the elements that are at play. But also, I'm not trained in the intergenerational mediation aspect as of yet. And so I would want to make sure that someone who was part of the team to help bring forward the best possible outcome for a family.
Sorry, just to expand on that, I guess, does everybody have to be in agreement? And I find that the most challenging part, because sometimes they say, well, I don't want that grandparents' views a part of this. So is it just the parents that end up like making that decision, that how many extended family members would be involved? That's where I've been challenged sometimes, where it's getting everyone's consent. Sometimes that can be tricky and hard to navigate. But
and so are there you may not have the consent for them to participate in the mediation,
right?
But can you allow for their input to come in a different way? Could they participate in writing something that's important,
right,
that the parents would consent to that also being reflected on in the same way as, not necessarily bringing the child into the mediation, but bringing their views into the mediation is done. with the
That's a
consent.
great tip. Thank
Yeah.
you.
In
And
terms
they
of,
can also participate by way of the intake too, right? So that's a way of hearing their voice directly. So if they're not, if all the parties aren't consenting to their participation at the joint session, you can certainly include them in the intake, at the intake stage.
And just to bridge this a bit to the child, like the child's voice piece as well, which is another generation of the family. It's really it's really important that the children know where their information is going to be going. So if you are going to have multi-generational family members involved, the child should either they should not be part of the relaying the child's voice, or the child should know and be okay with all of those people who are involved hearing their voice shared. So it's really important to be transparent, be very clear with the child and with everyone involved about what the process is, and that ultimately it's up to the child to forward their information or not to whomever they want or don't want. Of course, minimally the two parents, but beyond that, that would need to be worked in carefully.
Can I just make one more comment about third parties, including grandparents? It could be sometimes a close family member that someone wants involved. First of all, I think that it's all about being very clear about process and what is going to happen to information that all people bring you, and what's not going to, where it's going to go, where it's not going to go, even before they open their mouths. I mean, first of all, there's a certain amount of it in the contract, that the agreement, right? But there are things that people gloss over, so it doesn't mean it's enough to just hand over an agreement. But I think that, first of all, I think that people do have to agree if grandparents are going to be involved, and then in what way they're going to be involved. But let's not forget another thing. Third parties, grandparents, they're vulnerable too, because the agreement that's signed is between the parties. The grandparents may be involved, but they can potentially be more vulnerable with respect to, I'm going to say the term loosely, their rights in the process, because they're not included in that agreement. So doesn't mean that they should be included in the agreement, but we have to be really clear from the beginning about what the terms are. Like, so we should discuss it in the intake with the parties too. What happens, like if one of them wants grandparents involved, or even a second spouse involved, that comes up too. That has to be, I think, first of all, discussed in the intake, and we should be sort of inquiring about whether they want other parties involved, and then the process be very clear throughout. There's different ways of doing it. I don't think there's one way of doing it, but I think we have to be very aware of the importance of clarity of process and where information goes and doesn't go. That's all I have to say. And even then we can be hit with problems, but
yes.
no.
Yep. No, the transparency, the clarity of what's going to happen to that information, how it's all going to be incorporated in the planning process, etc.
Right.
Excellent points, everyone. I'm just cognizant of the time and everyone's precious time in terms of, we want to thank you for participating today, making your comments, asking your questions, coming out, and really raising some of the key elements that come to play when needing to think about how to include children, how to bring children's voices to planning purposes. And thank you all, and have a good afternoon.
Thank you so much,
Thanks,
Dan,
everyone.
Kim, and Vicky. Thanks everyone for coming.
Thank
I'll
you.
record it. It'll be on the website soon if you've missed a bit. Okay.
Thank
Thank
you.
you.
Thank you.
Thank you,
Bye.
everybody.
Bye.
Bye-bye.
Take care. I'm gonna sign off right away because now I have to go to advocacy meeting.
Yeah, I
Okay.
realized I was trying to help you out there.
Yeah, it's okay. I actually pushed it back to 2:15 because I knew this was gonna get lots of questions. So
Yeah.
yeah. Very, very good. Excellent job.
Thanks,
Thanks,
everyone.
thanks,
It was a
everyone.
pleasure.
you.
Okay.
All right.
Bye-bye.
Take care.